Good morning, Your Honor. Mohammed on behalf of the people.
Plea?
Yes.
Go ahead. Somebody tell me what it is.
Obstructing police officer under an attempt.
Mhm.
The second charge, which is malicious destruction of police property, it's the malicious destruction of property, $200 to $1,000. As part of the plea offer, we are requesting strongly that the defendant undergo a mental health evaluation and treatment if that is determined.
Yep.
As well as a substance abuse evaluation and treatment if determined, as well as full restitution for the property that was damaged in this case. And we're also requesting that the defendant undergo a pre-sentence investigation and defer to the court to the judge for sentencing.
Okay. Do we have the restitution number? Don't have one yet? Okay. All right. So submit that to my probation department as soon as you can. You talk to her, sir. You talk to counsel.
Your Honor, as Mr. Platoni's sentencing, can we look at whatever commission is, whatever receipt or whatever?
Yeah. Here's the way that's going to work. So at some point, if you enter a plea today, at some point in the future, we're all going to be, will you follow this for sentencing? Okay. So we'll all be back together for sentencing. At that sentencing, there'll be, in a report and recommendation, there'll be a request for restitution. So let's say it's $300. You think, yeah, okay, I'll pay that. If it's 30 grand, you might not want to agree to that. And then if we have to, we'll have a full blown restitution hearing. All right. So you're not writing me a blank check right now. You're saying that you've agreed to pay restitution. We don't know what that number is. I'll determine that if there's a discussion or an argument, I'll determine it at some point after everybody has a chance to be heard. All right. Does that help? Okay. All right. So did you discuss with your attorney your rights and your options? You understand those? Do you understand the possible penalty for an attempt R&O, resist and obstruct? And do you understand the possible penalty for the misdemeanor malicious destruction of property? Understanding all these things, are you pleading guilty to those two charges today? Are you doing so freely and voluntarily? Counsel, would you voir dire and get me the facts I need?
Mr. Platoni, sorry, she's been.
You want a date? Date would be 9/23/25 according to my paperwork.
I have to come into the time that the town was giving. At the time, they knew they were police officers, right? They were attempting to do their job, and you resisted or obstructed their ability to do their job, right? And when they placed you into, they ended up putting you into custody, right? They placed you in the back of the squad car, right? And while you were inside the squad car, you were kicking the door, correct? And even if you don't know the extent of the damage, you're aware that something is destroyed, right? Is what satisfied?
Your Honor, I'm going to request that there's a stipulation as to the amount of $200 to $1,000.
Stipulation.
Well, it's not a stipulation, it's the charge he's pleading to.
Yeah, so there's a fact, there's going to be a factual basis in place in regards to that element.
Agreed. So would you agree that the damage was somewhere over $200?
Thank you very much. Bye.
You all right? You agree? Okay.
The final thing is that the crime occurred in the city of Romulus, County of Wayne.
All right, now you're satisfied? So is the court. I'll dismiss the original counts 1 and 2. I'll refer him down to our probation department to schedule a pre-sentence investigation. I've also made a note in the file that mental health and substance abuse evaluations will be part of the sentencing. That means you're going to be evaluated. Whether or not I order treatment will be based on the results of that evaluation. Understood? Anything else, people?
One question in regards to the restitution amount. So the officer in charge who's here will just submit that to the probation department.
Yep.
Understood.
Yep. Obviously tied to this defendant's name. Yeah. Anything else?
That's on Mr. Almonte's line, but this project really does that.
Yeah, you any objection if the tether comes off?
I can just have an opportunity.
Sure, take a minute.
Emily Elijah called her at 11:30. She is running like leaving Third Circuit. Kevin Bassant just emailed Mary Ann. He's just wrapping things up in 16th and he's on his way for his 11:45.
You're on, refer to the court's discretion.
Okay. All right, there have been no allegations of any bond violations on this case.
No.
All right. I'll drop the tether requirement. I think the way that works is we do some paperwork and then he's got to go down and see them.
And then we'll have to take that down.
Okay, Mr. Almonte will be waiting.
Okay.
Waiting here, please.
Oh, and there?
Yes.
Nine seventy. Neighborhood better service?
And your name? Thank you. Counsel, go ahead and tell me about the plea.
We have arranged for a plea to misdemeanor under 7411. Ms. Kaczynski has been clean for nearly 8 years now.
Good for you.
We did-
Holy cow, this is an old one.
Yes, from
Did
20.
you see the file?
Doesn't clean down.
Good for you. Good for you. Go ahead.
This is going to be entered treatment shortly after, the underlying events of this case.
Mhm.
I had multiple letters of support from her. She does live out of state, Your Honor, so I was wondering.
Cincy?
Yes, remote sentencing if possible, or today.
I'll let you go talk to probation if they've got time to do a screening. I'll be happy to do it. Yeah. Yeah. If not, we'll figure something out. Okay. All right. So did you discuss your rights and options? You understand those rights? You understand those options? You understand the possible penalty for the added charge? Understand the possible penalty for, I rattled that off fast, for the added charge. Understanding the possible penalty and those rights and options, are you pleading guilty today?
Yes.
Doing so freely and voluntarily? Voir dire? Give me the facts I need.
Ms. Kaczynski on March. In March of 2016.
March 21/16.
March 21st in 2016, did you have contact with police? Yes. And were you in the middle of treating an individual's drug overdose? And when you made contact with police, did you tell police that there were more drugs located in your vehicle? Yes. And were there drugs located in your vehicle? Yes. Satisfied with the factual basis, Your Honor?
I am if you are.
Okay.
Yeah. So why don't you tell me more about the lady and maybe I'll just sentence her today.
You said, go.
Yeah, tell me more.
Your Honor, I do have a letter of support from her manager, if you'd like to see that.
Nope, I don't want to read it. Just tell me where you're working.
Your Honor, her manager that she works with at Ulta Beauty basically says that Ms. Kaczynski.
No, I don't want you to read to me. I just want to know, where do you work? What is that?
It's the cosmetics room operations manager,
Okay. How long you been with the company?
about 8 years, about 7 years.
Okay, long time. So where did you go to treatment at?
In Florida, went to recovery first.
Okay, okay. Tell me about the program.
It was a 30-day inpatient program. Talks.
Mhm.
Then I had intensive outpatient for about another month.
And what'd that look like?
It was going to every single night. I was going
That's intensive. Yep.
to group therapy, and then we would go to a meeting every day.
Good.
And then after that, I lived in a like halfway house
Yep.
thing for
Yep.
about 18 months or so.
Wow, long term. Good.
And then I stayed in Florida for until like 2022.
Okay, okay. But you've been with the same company all the time.
Yeah.
Okay.
I transferred from.
Okay.
Florida.
Must be a good employee.
Yes.
Okay. All right. Anything else you want to brag about? This is the time for it.
Well, I mean, I have been paying my own bills. I've taken care of all of my other stuff that I have dealt with from then. This is my last big piece. Rebuilt my credit. I have a car that I'm making payments on, insurance, all of that. So I'm doing everything
that I possibly can to
Good.
get myself together. and
Good.
Continue being a good member of society.
Good.
And Your Honor, the one last thing that I would note is, in this incident, Ms. Pazynski did call 911, which was the cause behind
Yeah.
her contact with police. This was in 2016, so
Yeah, we've gotten smarter since then.
it was just before, the Good Samaritan law were enacted.
Good for you. I'm proud of you and I just met you. Yeah, it's awesome. Good story. All right, so yeah, I'm not gonna wait for probation on this. 12 months, stay out of trouble, go away and sin no more forever. I'm not even gonna get your court costs. 8 years of sobriety get you something here.
Thank
You're
you.
welcome. You're welcome. What do you got?
This gentleman next.
What do you got?
We have a preliminary exam for Mr. Nyrico and,
What we just watched are actually two powerful examples of how the justice system handles very different situations. Let's start with the first case, the Romulus resist and obstruct charge. Here, the defendant admitted to resisting police officers while they were attempting to do their job. According to the facts presented in court, after being placed into the back of a patrol vehicle, the defendant began kicking the squad car door, causing damage. Now, at first glance, this might sound like a relatively small incident, but legally, it's actually taken quite seriously. When someone interferes with law enforcement officers performing their duties, it falls under a charge known as resisting and obstructing an officer. Even if there's no physical fight involved, simply interfering with officers or refusing lawful commands can trigger criminal charges. But what really made this moment stand out was the judge's explanation about restitution. The judge told the defendant something extremely important: "You're not writing me a blank check." What the judge meant by that is this: when someone causes property damage during a crime, they can be ordered to pay restitution, essentially reimbursing the victim or agency for the cost of repairs. But courts don't finalize that number immediately. Instead, the exact amount is determined later during sentencing. If it's a small amount, say a few $100s, defendants usually accept it. But if the number suddenly jumps into the thousands or tens of thousands, the defendant has the right to challenge it in a restitution hearing. That's why the judge emphasized that the defendant was not agreeing to a mystery bill right now. The system still allows room for fairness and review. Another important part of this case is the judge ordering mental health and substance abuse evaluations. This tells us the court isn't only focused on punishment. In many situations, judges try to understand why the behavior happened in the first place. If substance abuse or mental health played a role in the incident, treatment programs can sometimes be included as part of sentencing. That approach attempts to reduce the chance that the defendant ends up back in court again later. And then there was one final detail that stood out: the judge agreed to remove the electronic tether. For a defendant, that's a big moment. Tethers restrict movement and require constant monitoring. Removing it signals that the court believes the person has complied with their bond conditions so far. Now let's move to the second case, the one that might be even more powerful. This case dates all the way back to 2016, when police encountered the defendant during a drug overdose situation. Officers later discovered additional drugs inside the vehicle, which led to criminal charges. But when this defendant appeared in court years later, the story was completely different. Instead of excuses, the defendant explained everything she had done to turn her life around. She completed 30 days of inpatient treatment. Then she followed that with intensive outpatient therapy, attending recovery meetings every single night. After that, she spent 18 months living in a halfway house, which is one of the most structured recovery environments someone can commit to. And most importantly, she had maintained stable employment for years, paying her own bills, rebuilding her credit, and taking responsibility for her life. When she told the judge, "This is my last piece," she meant that this old case was the final leftover problem from her past. At that moment, the courtroom dynamic completely shifted. You could hear it in the judge's tone. Instead of skepticism, the judge showed something we don't always see in criminal court: genuine recognition of personal change. The judge ultimately sentenced her to 12 months of probation with minimal additional penalties, effectively allowing her to close the chapter on a mistake that happened nearly a decade earlier. And that's the key takeaway from these two cases. Courtrooms are not just places where people are punished, they are also places where judges evaluate accountability, honesty, and growth. In the first case, the court focused on responsibility for damaging police property and interfering with officers. In the second case, the court recognized years of recovery and rehabilitation. Same courtroom, same judge, but two completely different outcomes because the defendants arrived in court with very different circumstances and choices behind them, and that's what makes real courtroom footage so fascinating. Every case becomes a small window into how the legal system balances consequences with second chances. Now we want to hear from you. Do you think the judge handled both cases fairly? Should past mistakes continue to follow someone years later? Or should courts focus more on rehabilitation when someone clearly turns their life around? Let us know your thoughts in the comments below. And if you found this courtroom breakdown interesting, make sure to hit the like button, share this video with someone who enjoys real courtroom cases, and don't forget to subscribe for more jaw-dropping legal stories just like this one. Because here we break down real cases, real decisions, and the real moments that happen inside the courtroom.